in the heart of the American South during the 1950s and 1960s. A deeply rooted culture of racism and segregation thrived. Jim Crow laws and black codes enforced racial segregation and discrimination, particularly in the southern states. Though slavery had been abolished and black people had earned their freedom, they were in no way free. So, how did the historical context of racism and segregation in the American South during the 1950s and 1960s contribute to the challenges faced by interracial couples like Richard and Mildred Loving? Watch the video to the end to get all of your answer. White Americans still looked upon black people with disdain and considered inferior. It was in this hostile environment that the story of Richard and Mildred Loving unfolded. A story that would challenge the discriminatory laws of their time and change the course of American history. The Lovings' love story began in rural Virginia, a state deeply entrenched in the history of slavery and racial discrimination. Richard Loving, a white man, fell in love with Mildred Jeter, a woman of African American and Native American descent. Their interracial relationship was not only unconventional, but also illegal under Virginia's Racial Integrity Act of 1924. To understand the Lovings case fully, it is essential to comprehend the pervasive racial discrimination they faced in the United States during the mid-20th century. After the Civil War and the abolition of slavery, Southern states quickly enacted a series of laws known as Black Codes. These codes, together with Jim Crow laws, imposed racial segregation and upheld white supremacy. African Americans were systematically oppressed, denied basic civil rights, and subjected to segregation in all aspects of life, from education and public facilities to transportation and marriage. One of the most significant legal challenges the Lovings would face was the Racial Integrity Act of 1924, a Virginia law that prohibited interracial marriages and defined a white person as someone with no trace whatsoever of any blood other than Caucasian. Mildred Loving, a woman of African American and Native American ancestry, and Richard Loving, a white man, found themselves in violation of this law when they decided to marry in 1958. Virginia, like many other southern states, aimed to uphold racial purity and segregation through such legislation. But before the Racial Integrity Act of 1924, there were many other laws that upheld white supremacy and considered it an abomination for a white and a black to be in a pair. The first anti-miscegenation law was passed by the Maryland General Assembly in 1691, criminalizing interracial marriage. A belief in racial purity and white supremacy were among the reasons for such laws, with Abraham Lincoln stating in an 1858 speech, "I am not nor ever have been in favor of making voters or jurors of Negroes, nor of qualifying them to hold office, nor to intermarry with white people. I, as much as any man, am in favor of the superior position assigned to the white race." By the late 1800s, 38 U.S. states had laws banning interracial marriage. Before the civil rights movement of the 1960s, the overwhelming majority of white evangelical Christians in the southern United States saw racial segregation in marriage as something divinely instituted from God and held that legal recognition of interracial couples would violate biblical teaching. The prospect of black men marrying white women terrified many Americans before the Civil War. However, extramarital interracial unions were not rare and happened commonly between white male and black female. And although restricted to the lower classes, common law unions of black male with white female are not unknown. The Racial Integrity Act of 1924 was passed by the General Assembly to protect whiteness against what many Virginians perceived to be the negative effects of race mixing. The new law prohibited interracial marriage and ushered in a long period of discriminatory racial designation administered by the government. The act was based on the eugenics movement, which was gaining momentum at the beginning of the 20th century. Eugenics was the practice of controlling reproduction to alter the genetic characteristics of a population. Some advocates of eugenics believe that methods like selective breeding and sterilization would benefit human society by promoting beneficial traits. It was a movement that was used to justify white supremacy, resulting in discriminatory policies and heinous practices like forced sterilization. At the time, it was a fact that if a person is known to have 1% of African blood in his veins, he ceases to be a white man. The 99% of Caucasian blood does not weigh by the side of the 1% of African blood. The white blood counts for nothing. The person is a Negro every time. One of the act's main proponents was a physician named Walter Ashby Plecker. Plecker was born in Augusta County, Virginia in the spring of 1861. After securing a medical degree from the University of Maryland in 1885, he relocated to Hampton, Virginia, and began working as the public health officer for Elizabeth City County. He took a strong interest in obstetrics and helped reduce birth mortality rates by 50%. However, he was also a staunch advocate of eugenics and white supremacy. In 1912, Plecker was selected to serve at the head of the newly created Bureau of Vital Statistics in Virginia. As the head of Virginia's Bureau of Vital Statistics from 1912 to 1946, Plecker was responsible for ensuring that all infants born in Virginia received birth certificates that included their racial designation. An active eugenicist, Plecker used bureaucracy as a weapon against black and indigenous people across the state of Virginia. Eugenics argued that genetic purity could lead to a more utopian society. The idea was to select and support the proliferation of desired heritable characteristics through control over the parental rights of specific communities. Eugenicists, including Nazi Germany, used sterilization as a tool. On July 14, 1933, the Nazi government enacted a law allowing mass sterilization of those deemed genetically defective, including the deaf, blind, mentally ill, and persecuted groups like the LGBTQ+ community and Jews. The United States was no stranger to these cruel treatments, and likely informed the rest of the world on eugenicist practices. In 1907, the state of Indiana had passed the world's first sterilization law, and in 1924, the Virginia Sterilization Act was enacted, initially targeting the intellectually disabled. In his years at the Bureau of Vital Statistics in Virginia, Plecker pushed for the creation of Virginia's Racial Integrity Act, passed in 1924. The act outlawed interracial marriage and added strict definitions to racial classifications. It also criminalized the falsification of racial identity on legal documents, stating that the term white person shall apply only to such person as has no trace whatever of any blood other than Caucasian. Any who fell outside of this definition were to be identified as colored. While registration of racial identity was technically voluntary, it was required for things such as registering for the draft, enrolling in school, marrying, or issuance of a birth certificate. Racial identification was not limited solely to blood traces. The law allowed racial identity to be determined by things such as physical features and even family names. In 1935, a decade after the passage of Virginia's eugenics laws, Plecker wrote to Walter Gross, director of Nazi Germany's Bureau of Human Betterment and Eugenics. Plecker described Virginia's racial purity laws and requested to be put on Gross's mailing list. Plecker commented upon the Third Reich's sterilization of 600 children in the Rhineland, the so-called Rhineland bastards who were born of German women by black French colonial fathers. I hope this work is complete and not one has been missed. I sometimes regret that we have not the authority to put some measures in practice in Virginia, despite lacking the statutory authority to sterilize black, mulatto, and American Indian children, simply because they were colored. A small number of Virginia eugenics in key positions found other ways to achieve that goal. The Sterilization Act gave state institutions, including hospitals, psychiatric institutions, and prisons, the statutory authority to sterilize persons deemed to be feeble-minded, a highly subjective criterion. Dr. Joseph Dyer, director of the Western State Hospital in Staunton, Virginia, was a leading advocate of eugenics. DeJohnette wasn't satisfied with the pace of America's eugenic sterilization programs in 1938. He wrote Germany in 6 years has sterilized about 80,000 of her unfit, while the United States with approximately twice. The population has only sterilized about 27,869 in the past 20 years. The fact that there are 12 million defectives in the U.S. should arouse our best endeavors to push this procedure to the maximum. The Germans are beating us at our own game. By 12 million defectives, a tenth of the population, DeJohnette was almost certainly referring to ethnic minorities, as there have never been 12 million mental patients in the United States. According to historian Gregory M. Dorr, the University of Virginia School of Medicine, UVA, became an epicenter of eugenical thought that was closely linked with the national movement. One of UVA's leading eugenicists, Harvey Arness Jordan, Ph.D., was promoted to Dean of Medicine in 1939 and served until 1949. He was in a position to shape the opinion and practice of Virginia physicians for several decades. This excerpt from a 1934 UVA student paper indicates one student's thoughts. In Germany, Hitler has decreed that about 400,000 persons be sterilized. This is a great step in eliminating the racial deficiency. The racial effects of the program in Virginia can be seen by the disproportionately high number of Black and American Indian women who were given forced sterilizations after coming to a hospital for other reasons, such as childbirth. Doctors sometimes sterilize the women without their knowledge or consent in the course of other surgery. In the early 20th century, persons of color in everyday Southern society feared to voice their opinions due to severe oppression. Magazines such as the Richmond Planet offered the Black community a voice and the opportunity to have their concerns heard. The Richmond Planet made a difference in society by openly expressing the opinions of persons of color in society. After the passing of the Racial Integrity Act of 1924, the Richmond Planet published the article, "Race Amalgamation Bill Being Passed in Legislature." The journalist opened the article with Racial Integrity Act and gave a brief synopsis of the act. Then followed statements from the creators of the Racial Integrity Act, John Powell and Ernest S. Cox. Mr. Powell believed that the Racial Integrity Act was needed as maintenance of the integrity of the white race to preserve its superior blood. And Cox believed in what he called the great man concept, which means that if the races were to intersect, that it would lower the rate of great white men in the world. He defended his position by saying that non-whites would agree with his ideology. The sane and educated Negro does not want social equality. They do not want intermarriage or social mingling any more than does the average American white man wants it. They have race pride as well as we. They want racial purity as much as we want it. There are both sides to the question, and to form an unbiased opinion either way requires a thorough study of the matter on both sides. Racial minorities were not the only people affected by these laws. About 4,000 poor white Virginians were involuntarily sterilized by government order. When Laughlin testified before the Virginia 1924, he argued that the shiftless, ignorant, and worthless class of antisocial whites of the South created social problems for normal people. He said, "The multiplication of these defective delinquents could only be controlled by restricting their procreation." Carrie Buck was the most widely known white victim of Virginia's eugenics laws. She was born in Charlottesville to Emma Buck. After her birth, Carrie was placed with foster parents, John and Alice Dobbs. She attended public school until the 6th grade. After that, she continued to live with the Dobbses and did domestic work in the home. Carrie became pregnant when she was 17 as a result of being raped by the nephew of her foster parents. To hide the act, on January 23, 1924, Carrie's foster parents committed the girl to the Virginia State Colony for epileptics and feeble-minded on the grounds of feeble-mindedness, incorrigible behavior, and promiscuity. In 1924, Carrie Buck gave birth, and due to her declared incompetence, her daughter was adopted. Dr. Albert Priddy, a eugenicist, petitioned to sterilize her, claiming she was a genetic threat. Despite legal appeals, including Buck v. Bell in the U.S. Supreme Court, the order for sterilization was upheld. Justice Holmes argued public welfare outweighed individual bodily integrity. Carrie Buck was paroled from the Virginia colony for epileptics and feeble-minded shortly after she was sterilized. Under the same statute, her mother and 3-year-old daughter were also sterilized without their consent. In 1932, her daughter Vivian Buck died of enteric colitis. When hospitalized for appendicitis, Doris Buck, Carrie's younger sister, was sterilized without her knowledge or consent. Never told that the operation had been performed, Doris Buck married and with her husband tried to have children. It was not until 1980 that she was told the reason for her inability to get pregnant. Carrie Buck went on to marry William Eagle. They were married for 25 years until his death. Scholars and reporters who visited Buck in the aftermath of the Supreme Court case reported that she appeared to be a woman of normal intelligence. On August 2, 1947, Walter Plecker, the brainchild of the Racial Integrity Act, was killed by a vehicle strike in Richmond, Virginia. His policies and actions continued to impact communities for decades after his tenure and death. It wasn't until 20 years later that the prohibition on interracial marriage was overturned in the 1967 Loving v. Virginia case. Richard and Mildred Loving's love story began in rural Virginia, where they grew up in the small community of Central Point. Despite the racial tension surrounding them, their love blossomed. In 1958, they made the courageous decision to marry in Washington, D.C., where interracial marriage was legal. However, upon returning to Virginia, they faced persecution, harassment, and ultimately arrest for violating the state's anti-miscegenation laws. In 1959, after being arrested and sentenced to 1 year in prison or exile from Virginia for 25 years, the Lovings chose the latter option. They relocated to Washington, D.C., away from their families and the place they called home. It was during this exile that Mildred Loving penned a letter to Attorney General Robert F. Kennedy, explaining their situation and seeking help. Robert F. Kennedy forwarded Mildred Loving's letter to the American Civil Liberties Union, ACLU, which saw the Lovings case as an opportunity to challenge the constitutionality of anti-miscegenation laws. The Lovings, with the support of the ACLU, filed a lawsuit in Virginia's Caroline County Court, seeking to overturn the state's anti-miscegenation laws. Before Loving v. Virginia, there had been several cases on the subject of interracial sexual relations within the state of Virginia. On October 3, 1878, in Kinney v. the Commonwealth, the Supreme Court of Virginia ruled that the marriage legalized in Washington, D.C., between Andrew Kinney, a black man, and Mahala Miller, a white woman, was invalid in Virginia. In the national case of Pace v. Alabama in 1883, the Supreme Court of the United States ruled that the conviction of an Alabama couple for interracial sex, affirmed on appeal by the Alabama Supreme Court, did not violate the 14th Amendment. Interracial marital sex was a felony in Alabama, but the Supreme Court ruled it was an Equal Protection Clause violation. The ban on interracial marriage wasn't challenged in Pace v. Alabama. Lovings faced setbacks. Their 1960 conviction upheld anti-miscegenation laws' constitutionality. The Virginia Supreme Court of Appeals also ruled against them. The legal journey against anti-miscegenation laws continued until the 1920s. The Loving's 1967 Supreme Court victory ended anti-miscegenation laws. Despite legal gains, societal acceptance lagged, shown in events like the 1996 Georgia church controversy. Interracial marriages rose to 16% by 2015. Thank you for joining this enlightening exploration. If you enjoyed this video, please like, share, and subscribe. Hit the notification bell for updates on our upcoming videos. Remember, love transcends all boundaries.